Thank you, my lady. My lady, to finish a submission that I had almost finished, but I seem to have trailed off before I did. We were on BB just before the lunch adjournment. The final passages of the BB that I would ask the panel to look at in reaching a decision are also those of my lady's judgment at 41 to 43 and also 51 to 53, because therein my lady discussed the various categories of obstacles, positive and negative, and that there was a third category my lady envisaged of a hybrid between immigration and expulsion, which seems to be what this might be here today. So those paragraphs will also be of some relevance to the panel in reaching their decision. There doesn't seem to be any similar expose of that issue in other domestic curial hierarchy.
In these cases, yes. I mean, insofar as there is an important distinction between negative and positive obligations, are we in the realms of a negative obligation, don't remove her, or in the realms of a positive obligation, grant her permission to stay?
I think we are, if I can be bold enough to give an opinion, my lord, I would say we're in the realm of both, because the application is to not remove her. If there's a removal decision also, which, as I understand from my learned friend, there will always be nowadays, then it will be also, forgive me, it's the other way around, grant her and also don't remove her at the same time. That will certainly arise on appeal. You'll have both obligations. In this scenario, because there is no right of appeal and there is no removal decision at all, it seems to be still a mixture of both, because the right to respect for family life is clearly being interfered with in a more direct way than it may be said somewhat more marginally if someone is not in the country and they are said by the Secretary of State to be able to maintain their family life by modern means of communication. That can't be said where one's living day to day in the same accommodation as their spouse, and the spouse is being told to depart.
It's certainly primarily a negative scenario, because you say that interference is established, interference must be justified, must pursue a legitimate aim, and go through the 4 stages outlined by my Lord Reid and my Lord Wilson, Eden Bank, Melita, and Quilla. And if you act disproportionately, then you're in breach of Article 8. And the species of breach is that you have interfered disproportionately with Article 8 right. Is that right?
Yes, my lord, that is correct. I say it's primarily negative. To the extent that it may make a difference, I have attempted to distinguish that there is no ultimate difference when it comes to the question which the decision maker must pose, which is a fair balance or conventional proportionality. In terms, before we leave this topic, of the interference and how it is traditionally gauged in this country, that is classically framed by 2 authorities. One is a new authority I haven't referred to so far. It's AG Eritrea from the Court of Appeal, and that is to be found in the additional documents at item 6, but the MS number is 3408. Say 3408, but I shall also take that back in a moment when yes, 3417 is the precise MS number, and the paragraphs in question are 26 to 28. Herein, the court was discussing the various thresholds that have been canvassed in domestic and Strasbourg jurisprudence, considering Wang, Costello-Roberts, and ultimately what is said is that the threshold, or the minimum level as it's put, is not a specially high one anyhow. That is reinforced by a further decision of the Court of Appeal in VW Uganda, which I have already given references to in my written case, and that is, and therein it was said that the threshold is that it should be more than a technical or inconsequential interference with the protected right. So, at any rate, if you're suggesting the removal of a spouse, it's clearly more than a technical or inconsequential interference, we would say. Moving to jeunesse.
The second case the reference was?
The VW Uganda, the
VW
authorities tab reference for that, forgive me,
That's okay. That's all I need. Thank you.
it's volume 4, tab 38. Turning to jeunesse, there is a particular paragraph, I'm conscious of my lady's observation that I should raise something unique, which I say perhaps throws different light on the phrase exceptional circumstances. Jeunesse is at volume 6, tab 6 of the authorities, and not tab 6, forgive me, tab 76. And the MS number in question is 2454. And the paragraph I would direct the panel's attention to is 114 for a curious turn of phrase. We have at 114 the familiar sentence that we're confronted with a fait accompli, the removal of the non-national family member by the authorities who have been compatible in exceptional circumstances. However, that's followed by a very interesting line that, according to my research, has not appeared thus far in jurisprudence. The court must examine whether there are any exceptional circumstances which warrant a finding that the authorities failed to strike a fair balance in denying residence. So we have here a clear indicator, and it seems to be, and I'm sure I'll be corrected, for the first time in Strasbourg jurisprudence, that exceptional circumstances are to be used as a parameter, but engaging fair balance or proportionality. That is something unseen thus far, and it is fairly unique in that respect, because it isn't a parameter in terms of a threshold of compliance or a descriptor for how rare or unusual the case needs to be, but seemingly something to consider in terms of gauging the fair balance ultimately. So, at any rate, based on the guidance and the residual discretion, in my humble submission, it seems to be a different approach that's taken by the Secretary of State in her rules as opposed to that in jeunesse anyhow.
I'm sorry, which paragraph of jeunesse is that?
That was 114, my lord.
114, thank you.
And I use that as an example because in jeunesse, although there were no insurmountable obstacles, I just seek to remind the panel that the facts were still such that it could amount to exceptional circumstances. Now that isn't something that can happen under the rules, because as I've said, and I apologise for repeating it, if insurmountable obstacles are not met under the rules, this is not something which can, of course, go towards exceptional circumstances, because once rules are mandated to be refused, one must consider something exceptional, not already catered for by the codified rules. That's a fairly important point. It needs to be something new, something the Secretary of State hasn't already thought of in weighing or gauging where the public interest lies, in her view, of proportionality. Notwithstanding that, as I've already canvassed, our fallback position would be to rely upon Quilla, which of course the respondents say no longer is good law, and in particular paragraphs 33 to 43. A particular emphasis on 43 of Quilla, where there is a discussion of Abdulaziz and the fact that Lord Wilson said in his judgment, taking account of the Strasbourg jurisprudence, this is what we see as clear and consistent. Briefly touching on precariousness, in our submission, precariousness in domestic jurisprudence should not be used or cannot be used as a trump card. That seems to be the manner in which it's being waived here under the rules. And given the passages already referred to in the statement of case from Lord Bingham's judgment in EB Kosovo, it's clear, I think it's paragraph 15, that precariousness can diminish over time, or the passage of time, because of the extent to which ties are laid down, expulsion action is not affected by the state, etc. So that's something which clearly is binding on the Secretary of State and on the lower courts, and should form part of the considerations under the rules or outside them, again, there's nothing on this topic at all. And in fact, if anything, precariousness...
Sorry, did you say it can be extinguished?
Diminished, not extinguished.
Well, surely a better way of looking at it is the other factors assume a greater importance, and then it can be more easily offset rather than it diminishing in itself.
Yes, so when I say, perhaps it's the wrong adjective to use, when I say diminish, what I mean to say is that the legitimate aim would itself not hold so much weight in the balance or the fair balance exercise, because the legitimate aim could hardly be said to be important when it is being frustrated by the keeper or guardian of that aim. So that is the rationale, I say, on why Lord Bingham's judgment would remain sound regardless of the alleged clear and constant jurisprudence which would diverge from that. So in terms of jeunesse and this topic, it does in fact arise, not squarely, but it does feature in jeunesse. So moving back to jeunesse just momentarily, at tab 76 of volume 6, the paragraph in question is 103, and that appears at MS 2452. And it's largely the first sentence of that paragraph, where a contracting state tolerates the presence of an alien in its territory, allowing him or her to await a decision on application, an appeal against such a decision or a fresh application. So there's various types of allowance there for someone to remain. Such a contracting state enables the alien to take part in the host country's society, form relationships, create a family there. It goes on, of course, to say the familiar text, that it doesn't automatically entail that the authorities are under an obligation to allow him to settle there, but that doesn't necessarily mean that it wouldn't counterbalance or feature in the balancing exercise in terms of the length of residence, for example. So this is yet again another factor which has not been considered either under the rules under EX1B in the decision letters or in the exceptional circumstances consideration, either explicitly in the letter or by implicit reference within the guidance. It simply does not appear that precariousness is not a fixed measure and that it can change or vary or fluctuate owing to the passage of time and factors such as this. Staying with jeunesse just momentarily, there is also another anomaly to be seen in the judgment, which does chime to a certain extent with my previous submissions regarding Zambrano, which I think I promised Lord Reed I would try and come back to. So it's in the judgment at paragraph 110, one can see, and 110 is, forgive me, I forgot to give the MS reference, is 2453. One can see that the applicant in jeunesse did in fact raise the issue of whether the decision would breach Article 20. As the court says here, as to the applicant's reliance on Zambrano, the court emphasizes that under the terms of Article 19, 32, etc., it is not competent to apply or examine alleged violations of EU rules unless insofar as they may have infringed rights and freedoms protected by the Convention. But it's clear that what was pressing here most was the family life. It wasn't an added factor per se that was necessary because there were exceptional circumstances anyhow. But to the extent that it may not be covered, it's said, more generally, it is primarily for the national authorities, notably the courts, to interpret and apply domestic law in conformity with EU law. The court's role being confined to ascertaining the effects of such adjudication are compatible with the Convention. So there we have the Zambrano ratio being canvassed by the Grand Chamber. They have declined to look at it, but it is something, of course, that they encourage the domestic courts to look at and abide by. So all I would say is, even if the court is not with me in my arguments regarding Zambrano, the ratio, of course, still must be respected. And in my humble submission, it's something that should be repeated, or at least reminded to the lower courts, in terms of that being an important right and the consequence of citizenship of the Union, albeit it's not a convention-based topic. It is something that can obviously arise, and I have done my best to illustrate how that is so in day-to-day matters such as the application of EX1B and the terms of the guidance where British citizens' rights, I say, are not taken into account.
Since you've mentioned Zambrano, I should perhaps mention that I found the Advocate General's opinion in the CS case
Yes.
you mentioned earlier, and it seems to be like Zambrano, a case about dependent children. It was an automatic deportation case.
Yes.
And if the mother was automatically deported, the children were inevitably going to go with her because they were EU citizens. So it's squarely within the ambit of Zambrano, whereas in the present case, you're, I think, trying to extend it to an adult partner.
The only reason I fully accept what my Lord says, I should say first, and that is indeed a correct reflection of the Zambrano and CS analogy there. This is not a deportation matter, but the application of the ratio of Zambrano in Senade, for example, at the time the Secretary of State did accept that it can overlap in terms of removal or deportation. There was an alternate there that the President had canvassed and agreed with based upon what the Secretary of State had said. So I'm not seeking to introduce it, but it's something that the Specialist Tribunal has already said can occur. The reason I'm able to make this submission is not through anything as such which the applicant has pursued in their application. It's because of the manner in which the respondent decides to assess the rights of British citizens. It's because of the cursory, or even I would say non-existent nature of her assessment of those rights of partners that I'm able to raise this argument. Were she, of course, to change the rules or to reflect that her rules must, of course, abide by such ratios, then I wouldn't have pursued this argument at all. Briefly, I would...
Where are we? You've exceeded your time by 5 minutes.
My lady, yes, I as a canvass this morning, I did discuss with Ms. Giovanetti that I might go to 2:30, which I will probably do.
Good, excellent, as long as that's...
Yes.
And I'm quite happy, my lady.
My lady, there are references made to anxious scrutiny arguments and things of such a nature. I only want to give page references to the reasons why I say that might be correct against the guidance. The May 2013 guidance appears, as we have seen, in the appellant's additional documents. The relevant paragraphs for the refusal letter paragraphs within, give me one moment. Are at MS 3279 is where the paragraphs begin, and they go on for several pages. The relevant ones, they're not all relevant, but the relevant ones are, of course, discussing applying for leave to remain, but being refused due to, in the case of Miss Ikuga, failing on a genuine and subsisting relationship, and in terms of the refusal for Miss Agyarko, it would be in relation to exceptional circumstances, and those. So, if I can give the internal page numbers.
3294 is failure on genuine subsisting relationship.
I'm grateful, my lord. The exceptional circumstances paragraphs appear on 3286. And I'm only touching upon them for one moment because they are of curiosity. These are, of course, what one sees in refusal letters, day in, day out. It's curious, I say, that the exact paragraph that appears at the top of 3286 appears precisely on the same terms in Ms. Agyarko's refusal letter. But the implication of it is that there are no exceptional circumstances at all. Now, there is no explanation as to why. The refusal letter wording is suggested as the outline, as it says on 3279, MS 3279, sorry. The following wordings are examples. And reasons must, of course, be given. So there are no reasons given underlying the no exceptional circumstances raised point. In terms of Miss Ikuga, there was a consideration of exceptional circumstances that raised her health concerns. So the paragraph below on 3286, which is quite impenetrably termed possible exceptional circumstances raised, seems to imply that there is something exceptional which hasn't already been considered. In this case, it was her health conditions, but there is no mention explicitly of her partnership with her British partner. Now, it's important to recall that there was no assessment given to that for reasons which were flawed, as seen by the upper tribunal earlier, but it was thought ultimately that there wasn't anything exceptional, is what the upper tribunal said in refusing permission. But the term exceptional is, of course, gauged by this paragraph as an illustration, and also by the guidance, which makes it clear that it has to be something over and above what's already considered by the rules. But the difficulty is that if the rules haven't allowed for a consideration of one's partnership, and the exceptional circumstances don't also do so, the partnership hasn't been considered at all in the case of Miss Ikuga. So there is no assessment of her partnership. Certainly, I anticipate my learned friend will say that there has been under the rules, but outside the rules, on conventional proportionality, there's nothing at all.
Well, in the Mrs. Ikuga's case, the decision letter is based on the evidence. You've provided no evidence to show you've been living at the same address as your partner, and therefore you fail to meet Gen 1.2. You therefore can't be seen to have a partner under Appendix FM.
That's correct, my lord, and that was said to be wrong by the upper tribunal, because there was evidence in the form of the partner's...
It was late evidence, wasn't it?
No, it was evidence sent a few days before the application was refused,
Yes.
but it wasn't considered.
Yes.
So there was an omission there, which points to lack of anxious scrutiny anyhow, but the point being, the caseworker, we don't even know on the face of this letter whether they were aware that the partner had written a letter. It's not considered in its terms, and this is an illustration of how the failure to consider specific evidence can lead to such generic refusals, which do not portray reasons which are required.
Well, is that not just a straightforward domestic administrative law ground of challenge, a failure to have regard to material consideration?
Forgive me, my lord, I missed the...
I wonder if there isn't there just a conventional domestic administrative law ground of challenge, if there was material evidence submitted which the decision maker has failed to take into account.
That was indeed one of the bases that was canvassed before the upper tribunal, and it succeeded, and so matters did not go further on that point. But the extrapolation of that is that there hasn't been any consideration of the partnership under proportionality at all.
But surely the partnership is the foundation of the Article 8 claim.
Yes.
Yes, absent the partnership, there is no claim.
There is
So
no
to
claim
say
at
that
all.
it hasn't been considered seems to be somewhat artificial.
Well, there is no claim, because if the Secretary of State writes a letter saying, we don't accept you're in a partnership because you have not given us evidence of living together for 2 years, firstly, that violates the decision of the Strasbourg court in Appellant versus Russia, which makes clear that you don't need to be living together or married necessarily, but one can simply have a partnership. Partnerships engage Article 8. So clearly, Gen 1.1, I think it was, violates Appellant versus Russia. But besides that, if one needed those 2 years' worth of evidence, and actually it was given in the form of the partner's letter, which the upper tribunal accepted, that means there was a deficiency on its face in the refusal, and it should have been considered by the Secretary of State because, as is stated in our written case, the residual discretion belongs to her. It's the property of the executive to give or exercise a decision by considering the residual discretion.
The upper tribunal said it considered it and said it didn't make any difference.
Well, my lord, I say
That's
that
the
that's...
decision you've got to challenge. Right?
You won on this point in the upper tribunal, didn't you?
I did, my lord, yes. But the point is that the upper tribunal said there was nothing in it because of applying exceptional circumstances.
That you couldn't have succeeded anyway.
So one can't succeed anyhow. It's a circular argument, but it's also a loser's game, playing the...
Well, the question is whether the upper tribunal were right. We're not concerned with whether the Secretary of State got it right.
Well-
We're concerned with whether the upper tribunal got it right.
Indeed, my Lord. My Lord, I say that the upper tribunal was wrong because of applying the exceptional circumstances approach, which the Secretary of State has done. So in following that, and in not applying conventional proportionality, of course the upper tribunal fell into error. But it perhaps can't necessarily be blamed because of the various authorities passing overhead, which go both ways, it seems.
Well, as it's judicial review of the Secretary of State's decision, I think we are concerned with whether the Secretary of State's decision was correct.
Well, my lady, I say the decision was clearly flawed. The upper tribunal accepted that. And it required anxious scrutiny, particularly given that the partner's letter, the reference to his daughter wasn't mentioned, the reference to his son wasn't mentioned.
Yes, in order to get leave to move for judicial review, you've got to do more than establish that there was a flaw in the decision. You've got to establish that it'll do you any good.
Well,
And
my lord,
that's where you fail. I mean, my lady's obviously right, if I may say so. We are concerned with the decision letter. But the question is whether you should have leave to judicially review it. And if you were never going to succeed anyway, which is what the upper tribunal said, rightly or wrongly, then you don't get leave, do you?
I understand that, my lord. I say it's wrong, though, because if one doesn't consider the partnership for reasons which contravene Strasbourg, that's one flaw in itself. Leaving that to one side anyhow, if you don't consider the partnership itself and you don't consider the ties that the British citizen holds, such as having children, and I'm conscious of the fact that the respondent has criticised in a supplementary statement case the statement of facts and issues which have raised all relevant facts and issues, but albeit that not all the children were mentioned, some of them were mentioned in the application, particularly the son and the daughter, and it was said that the daughter does share a relationship with her father and Miss Ikuga, the appellant. So that's a glaring omission there. Why should those rights of the partner, the relationship he shares with his daughter, the relationship the daughter shares with the appellant, not feature in a decision at all? How can one know that it's even being considered? The answer is you can't. And that's plainly unreasonable in Wenthree terms. I believe I've reached the end of my allotted time. I'm grateful.
Well, thank you very much, Mr. Saini, and we express our renewed sympathy that you don't have a junior for us to call upon to follow you, although I'm sure they would want to do so.
Of course.
Thank you very much indeed.
Thank you,
Could I ask a very quick question?
Of course you may.
Yes, my lord.
Over the short adjournment, I looked quickly at the IAA case recently decided in Strasbourg. It's only an admissibility decision.
Yes.
And my eye was caught by a sentence at the top of 3587. You've got that to hand, Mr. Saini.
I'm just turning to it, my lord.
It's the last sentence of paragraph 40. In answering this question, that's referring to it, the court, has had regard to the existence of any insurmountable obstacles or major impediments to the parent's return. See to quabo tecle. Now, I don't think we've got that in our bundles, have we?
We
Mr.
do not, my
Saini?
lord. No, we
but
do
I
not.
just wondered whether it looks as if major impediments is a quote, possibly from to quabo tecle. And speaking for myself, tomorrow it might be interesting to see the paragraph, if it exists, in which that apparent equiparation of major impediments with insurmountable obstacles exists.
My lord, we do not have the authority.
Could you look into that briefly?
I will, my lord.
Thank you.
I'm grateful.
My lady,
Yes,
my
Mr.
lords.
Yes.
In our respectful submission, the key question on this appeal is whether the scheme comprised by the immigration rules, together with the potential for the exercise of discretion outside those rules, is compatible with Article 8 of the Convention, and whether lawful decisions compatible with Article 8 were reached in these two appeals. I propose to address first Article 8 on the basis of the Strasbourg jurisprudence, then Article 8 on the domestic authorities. Thirdly, I'd like to look in a little bit more detail at the scheme for leave to enter or remain as a partner. Then, and I suspect this will be tomorrow, I will briefly address Chikwamba, Zambrano and Derecci and the facts of the individual cases. And I hope all of that can be accommodated in the time available. In the course of discussion between members of the Court and my learned friend, there's been debate about whether the question is, do the rules comply with Article 8, or whether the question is, does the scheme, which comprises the rules plus discretion, comply with Article 8, or sufficiently provide for a proper Article 8 assessment? In our respectful submission, it is clearly the latter. There are some areas where the immigration rules themselves have been held to constitute a complete code. So, for example, in the first of the 3 series of appeals, in criminal deportation, the rules themselves provide for consideration of all the circumstances. In the present context, they don't. And it's been the Secretary of State's position for a long time, even if not clearly stated in Isuazu, that you need to look at the rules and discretion together. And could I briefly, we'll come back to this in more detail in due course when I look at the scheme, but just as a starting point, could I ask you to turn briefly to the authority of Nargray, which has been referred to, I think, a number of times in the course of all of these appeals, but I don't think we've really gone to it very much. It's in Volume 5 at tab 52. It starts at MS 1625.
While we're going there, could I just ask you, you said that in some areas, you gave one example, the rules have been held to constitute a complete code. I think that's at Court of Appeal level, isn't it?
Yeah. Oh, absolutely, yes.
Yeah.
MF Nigeria.
And the question is, in fact, currently under consideration by this court.
Yes. Yes, I didn't mean by this court. No, obviously that's one of the key issues before you in the criminal deportation appeals. But it's been the Secretary of State's position that the criminal deportation rules are a complete code, and that's been upheld at the moment on the basis of the Court of Appeal case law.
But it is not the Secretary of State's position in relation to
leave to enter or remain. Yeah. Precisely, yes. And if we turn firstly briefly to MS page number 1638, it's paragraph 33 of Nargray. You'll see from the first page that Nargray was decided in March 2013, so this isn't recent.
What was Nargray about? Just remind us.
Nargray was about the compatibility of EX1. It's absolutely on point.
Sorry, which paragraph again, please?
Paragraph 33, my lord, MS 1638. I'm happy to read it out if the court would like me to, but you may prefer to read it yourselves.
31.
Sorry, my lord, 33.
33. Well, the Secretary of State doesn't contend the new rules completely cover every conceivable case.
Yes. And then I'd ask you, if you have time, to read the whole of the section between paragraphs 28 and 49. But if I can just point out for the present purposes paragraph 33, then paragraph 35, the important points for present purposes are that there is full coverage of an individual's rights under Article 8 in all cases by a combination of the new rules and, so far as may be necessary under the Secretary of State's residual discretion, to grant leave to remain outside the rules. And 36, claimant's challenge fails. No matter how closely or not the new rules track the detailed application of Article 8 in individual cases, the immigration control regime as a whole, including the Secretary of State's residual discretion, fully accommodates the requirements of Article 8.
This was a challenge to the rules,
It was.
not to decisions in individual cases, wasn't it?
Well, I think there was a challenge to the individual case as well, from recollection. I should know because I was in it.
Yes.
But the key point...
This was an individual case, wasn't
Yes, it was.
it? Looking at 15.
Although I think, a lot of the argument was about the scheme, as so often happens. But the key point I'm taking you to this case for now is just to demonstrate that the Secretary of State's position has always been that you look at the rules plus discretion in this context.
It was a challenge to the addition of EX1 to the rules in 2012,
Yeah.
from paragraph 1.
And then at paragraphs 50 to 52 at the end, the court considered the challenge to the decision in the claimant's individual case. But a lot of the argument was taken up by the scheme.
Yeah.
And just while we're there, paragraph 49 is interesting and is much cited. And that's Mr. Justice Sales, as he then was, cautioning against a tick box approach and reminding the Secretary of State of the need to look carefully at the facts of each case. And that is how things have proceeded in the intervening 3 years. I'm not trying to say it's, there aren't cases where there's room for criticism, but that's what the scheme has been understood to be and how it operates. So, just to be absolutely clear, it is not my submission that the rules themselves perfectly mirror Article 8 or will always provide an Article 8 compliant result. Insurmountable obstacles in EX1 is not the test for Article 8. It is a criterion for the grant of leave under the rules. The scheme envisages that there may be individual applicants who cannot satisfy the insurmountable obstacles test or criterion, but will still succeed. And that's why you have the residual discretion. So one has to look at them both together.
Well, do you accept it is no more than a factor?
It's no more than a factor for Article 8 purposes. It is the test for EX1. So if you succeed in demonstrating insurmountable obstacles, you succeed under the rules, and there's no need to go on to consider the exercise of discretion. For the purposes of Article 8, considered in the round outside the rules, it's a factor. It's no more than a factor. That's what the Court of Appeal held in these appeals, and we'd respectfully say that's plainly correct. If I put it another way, the Secretary of State didn't need to have EX1 in the rules. She didn't need to provide that you could succeed under the rules on the basis of insurmountable obstacles. That could have been omitted completely. All it's done is enable a class of claims to succeed without having to go any further. Even if it wasn't there, she'd still have to look at insurmountable obstacles as a factor when she came to exercise her discretion.
Trying to help the applicants, really.
Precisely, yes. Yeah, well, it is. It's a clear class where the decision maker can say, I don't need to go any further. There are insurmountable obstacles, therefore it succeeds.
Right.
So, as we discussed in one of the previous appeals, this is an example of an inclusive, not exclusive criterion. Somebody will not be refused on Article 8 grounds on the basis they don't satisfy EX1, but they could succeed on that basis without more. So, turning to my first heading, Article 8 in the immigration context, obviously, in the Strasbourg case law. I wonder if I could start by making it quite plain that I don't depart at all from what my learned friend says about the need to strike a fair balance in all cases. But that's because the fair balance principle is inherent in the whole of the Convention. The Convention is all about weighing the public interest against the interests of individuals, quite outside Article 8. So, for example, even Article 3 forms part of the fair balance. The Convention operates so that it recognises that the public interest, for example in national security, can never justify torture or cruel or inhuman or degrading treatment. So in Article 3 cases, the balance is always in favour of the individual. That is a right which can never be infringed. We see that demonstrated quite plainly right back to Söring and Uller, and I wonder if we could just briefly turn that up. Volume 2 of the Authorities, tab 15. Uller starts at MS page number 522. And at page MS 540, paragraph 10, Lord Bingham commences quite a lengthy discussion of Söring. If we turn over to MS 542, its internal numbering is paragraph 89. It's a citation from Muller. It's, from Söring, which I'm sure will be familiar to all of the court, but I think it might be important just to look at that as a starting point. What amounts to inhuman or degrading treatment or punishment depends on all the circumstances of the case. Furthermore, inherent in the whole of the Convention is a search for a fair balance between the demands of the general interests of the community and the requirements of the protection of the individual's fundamental rights. So every Convention case involves the striking of a fair balance. But the way that balance is struck will depend very much on the context and the circumstances. And that's why, in my respectful submission, jeunesse is very important. It's become clear that although domestic law contains distinct schemes for the determination of leave to enter, leave to remain, and deportation on grounds of public interest, including criminality, for the purposes of Article 8 in immigration cases, the key distinction is between settled migrants, broadly speaking, persons who've been given residence rights in a particular state, and others. In particular, amongst those others, persons who seek to rely upon family or private life established while their immigration status was precarious.
Well, it may be a key distinction in Strasbourg case law, but it may, in a sense, but it may not translate into domestic law in quite the same way because of the way our legislation deals quite separately with issues of immigration control and issues of deportation because of criminality.
Yes. The precise procedure for applying it, or the scheme in which it's applied, will vary on the basis of the domestic context. But in looking to see whether a decision breaches Article 8, in my respectful submission, one has to look to the Strasbourg case law to see what the content of that right is. And I will spend a bit of time on the domestic authorities in...
You have to identify if legitimate aim pursued. And legitimate aim pursued in an immigration control case is different from the aim pursued in a deportation case.
My Lord, I would accept that, but before one even looks to see what the legitimate aim is, one has to look to see whether there's an interference. We look at the steps in Rasgar. Rasgar says, is there an interference? If so, is that interference in pursuit of a legitimate aim? And you then look at justification and proportionality. And in my respectful submission, one of the important features of jeunesse is that it clarifies that that's absolutely right in cases when you're proposing to remove the residence rights, to deport, in short, a settled migrant. That is an interference, and in order to justify it, the state needs to be able to point to sufficiently serious reasons, which will generally be the seriousness of criminality and all the sort of public interest factors in favour of expelling that person. in cases where somebody doesn't have residence rights but is asking for them, so as in these cases somebody's asking for leave to remain, the starting point is different. So there isn't an interference that needs to be justified. The individual concerned needs to demonstrate that there are circumstances which call for the grant of a right, the grant of residence status. And that's the difference. That's why it's important whether it's a positive or a negative obligation.
Well, one has to distinguish between the grant of a right to residence and the right to a family life, does one not?
Well, could we start by looking at jeunesse?
Yes,
yeah, well, I think we do need to go back to it.
In jeunesse, you didn't refer to this line of thought at all in the Ali hearing.
I beg your pardon?
In the Ali hearing, this argument wasn't put.
No.
And Ali was a case of somebody who was not a settled migrant within the meaning of the Bultif line of authority. No. But it was common ground that that was a line of authority which governed the correct approach.
Well, yes, I appreciate that, and I've been worrying about that quite a lot since the Ali case. and to be absolutely frank, I think it's enormously helpful that this court is dealing with these three appeals in sequence, because in the course of the Ali case, there are a number of authorities I relied upon, and the response was often, well, those are immigration cases. So I went away and read them very, very, very carefully to understand where the distinction was between an immigration case and a non-immigration case. And it became apparent on reading jeunesse carefully, and not just the text, but also the footnotes, that the distinction the court was drawing there was not between whether it was a deportation or an entry case. It was drawing a distinction between settled migrants and persons whose immigration status was precarious, to put it broadly. And so it started off by saying Bultif, Maslov and Una, it didn't say those were criminal deportation cases, it said those were all cases concerning settled migrants. And of course, when you look back at them in that context, it becomes clear. And in my own defence, I would say only that the domestic case law has not previously drawn that distinction at all clearly. But when you look back at the cases, it seems to me it's a distinction that is founded in the court's case law, and the authorities all fall into one or other of those two lines.
It's unfortunate the point is being raised at a stage when Mr. Hussain is no longer able to reply to it.
It is, and were the court minded to invite him to make further submissions on this, obviously I wouldn't object. I've been trying not to, at the moment, bring us back into the criminal deportation context, but obviously it's relevant, because it seems to me the fact that a person who is a precarious migrant commits a criminal offence couldn't conceivably put them in a better position than somebody like these applicants who hasn't committed a criminal offence but can't rely on their relationship, in our respectful submission, in the absence of exceptional circumstances, because they were not lawfully here when they developed family life.
Now, I don't want to keep you away from jeunesse because I know you're anxious to get to it, but
Yeah.
just as a preliminary, do I understand your argument to resolve to this, that entitlement to an Article 8 right is dependent upon your status as a settled migrant?
No.
Oh, I see. Well, then we better go to jeunesse. And
Yes.
No, you say it's different, but there is still an Article 8.
What I say is that there is an established right if you're a settled migrant, and the test under Article 8 is, has the state legitimately interfered with that or illegitimately interfered with it? Is there an unlawful interference?
Yes.
In the case of a sorry, my lord.
No, please go on.
In the case of a non-settled migrant, the question is, are the circumstances sufficient to give rise to a positive obligation? If they are, that's the end of the story. There's no question of justification. If you're entitled to be granted a residence right, that's it. But you have to show strong circumstances in order for the court to say you have that right.
But are you saying that there isn't an interference in a non-settled migrant case, unless there is a positive obligation to admit?
I put it slightly differently. In a non-settled migrant case, the question isn't whether there is an interference. The question is whether there's an obligation, a positive obligation. I suppose it amounts to much the same thing. If there's a positive obligation, removing you in the face of that obligation would be an interference. Yeah. But if you're entitled, if the state has a positive obligation to allow you to remain, that's the end of the story, really. In the final analysis, the result, I may say, is not likely to be very different because Nargray was approached on the basis that it was an interference, but a proportionate one, but it still applied the exceptional circumstances test. But I would say that having the correct analysis is important because otherwise things tend to go wrong because people start asking about the justification for the interference. And the question isn't, is there a justification for the interference? The question is, are the circumstances of this case sufficiently strong, exceptional, or compelling to give rise to a positive obligation?
And unless they are, there isn't any interference.
That's right. Yes, that's right.
Well, at the very least, you say, do you, that however you pose the Article 8 question, in the case of a non-settled migrant, you can collapse the test into, are the circumstances such as to require admission?
Yes. Yes.
And if you answer that yes, easy,
Yep.
well, in fact, either way, it's easy. But that will determine it, you
It
say.
will. Yes, it will. Well,
It's just another way of asking the question, isn't it?
it has led to enormous difficulties when it's not asked in that way. And I didn't want to deal with it in these terms, but if you look at Mr. Ali's case as an example, the tribunal started off by saying this is an interference. Is it justified by the seriousness of his offending and by the risk of reoffending? But in fact, Mr. Ali was not a settled migrant at all. The court should have been saying, are the circumstances sufficiently strong to impose upon the UK a positive obligation to require him to stay? They ended up adopting a very much more generous test towards him because they equated his situation with that of a settled migrant in the Una, Bulteef, Maslov cases. And that's the sort of thing that happens if you don't draw a distinction between the positive obligation cases and the negative obligation cases, in my respectful submission.
I can understand the danger of which you speak, but if you were to say that, yes, of course, it is a question of balance, it is a question of reasonableness, but in the precarious migrant cases, there is a great weight is attached to the public interest to maintain a proper immigration system, and great weight is attached to the fact that the relationship was entered into knowingly in circumstances of precariousness, and therefore exceptional circumstances are required. That might achieve exactly the same result.
Well, yes, it probably would. It hopefully should lead to exactly the same result. However, we have a recent Grand Chamber decision which sets out the Strasbourg Court's analysis. And it's an analysis which is not very far removed to our own, but there are aspects of it that we've departed from domestically. And in my respectful submission, that's tended to cause confusion. And if we have a definitive decision of the Grand Chamber saying this is the right analysis, I can't see any basis for the court saying it shouldn't follow it. But obviously, that's a matter for the court. But in my respectful submission, it should be followed. It's clear, it's coherent, and it's correct.
So the result in these cases so far, which is that if the relationship is to continue, it should continue in Ghana and Nigeria respectively, you say that that prospect does not amount to an interference with respect for the family life of these two couples?
Yes, I do.
You do say that?
I do say that.
And it's because you say there's no interference in these cases that you say we don't get on to proportionality. Is that right?
I say because there's no interference, we don't get onto proportionality. That's step one. Step two is these are precarious cases and there are no exceptional circumstances. So that the relationship was formed at a time when they weren't here lawfully. These were not settled migrants. And there are no exceptional circumstances which would justify imposing on the United Kingdom an obligation to grant them leave to remain.
Do you quarrel with the way? Do you take issue with the way the matter was dealt with in BB?
Oh,
I mean, effectively, it's saying, as I understand it, that the fair balance assessment required by jeunesse in order to decide whether there's a positive obligation is analogous to the proportionality assessment where there's an interference. But there are some differences between the factors, and jeunesse indicates relevant factors such as precariousness and the importance of immigration control and so forth.
Well, I didn't find BB altogether easy to follow because, sorry, I don't have the bits to hand now, but I'll give you the passage numbers tomorrow, if I may, first thing in the morning. As I read it, Baroness Hale accepted that following jeunesse, interference wasn't the right term to use, and that wasn't... But then...
Well, I think I accepted something similar in the Aquila.
I think you may have done, yes.
That because Rodriguez de Silva preceded Aquila, so this distinction that is repeated in jeunesse is not new. It was known to us at all times, but we took the view that when you're asking what the fair balance was, you would be engaging in much the same sort of analysis as you would be engaging in an interference case, though the factors would be different.
I'm getting into much deeper waters than I anticipated so early in my submissions, but if I could...
Well, we did the same to him, so...
Oh, no, I'm not complaining. I just want to help the court as much as I can and put my case as clearly as I can, just to do justice to the argument. Although, as my lady says, she appears to have accepted in Beebe that we're not in the realms of interference, Lord Neuberger starts his speech by saying the question is whether the interference is justified. And the analyses are different. And in Quila, the court started off by saying, or Lord Wilson started off by saying, that this was a colossal interference which required weighty justification. Whereas what we see from jeunesse is that in leave to enter or remain cases, the question is, has the applicant shown something particularly compelling? It's not for the state to show justification for the interference, like criminality in the Gulteef, Una, Maslov cases. One looks at the applicant's circumstances to see if they call for the grant of a positive right to remain.
Were you? I mean, I think you were going to take us to jeunesse and then take us to the domestic authorities so we can see how jeunesse has been applied or qualified, because otherwise it's sort of the wrong way around.
Should I do that?
Well, for my part it would be, but I don't want to.
No, I'd very much like to do that.
I haven't been involved in some of these other cases, so I'm sort of a step behind some of my colleagues.
So, the facts of jeunesse will be familiar. They're at H1 to H6. Sorry, it's in the Authorities, Volume 6, tab 76, as I'm sure the court knows by now. MS 2427. I won't take you to the facts again because I know we've looked at them in the previous appeals. But what you'll note is that the applicant arrived in the Netherlands on a visitor's visa, that's in H1. She didn't return to Suriname when her visa expired at the end of H1. H2 made various applications for a residence permit over a number of years. And then we see at H3 and H4 and H5 that she had a number of children. The first child born in September 2000, so in early teens by the time the matter came before the court.
And she managed to keep going from 1997 to 2012 with
Yeah, she did.
succession of appeals. And
Yes, exactly. And this, for what it's worth, this wasn't an applicant who'd gone to ground and was sort of living secretly. She was pursuing, and that's one of the factors the court took into account, she was pursuing applications and appeals.
Yes, I mean, they knew all about her and they thought they tolerated her.
Yeah, precisely. So the key paragraphs in my respectful submission are paragraphs 103 to 108 and footnotes 24 and 28. And they're all important, but if I could pick it up for present purposes at 104, the instant case may be distinguished from cases concerning settled migrants, as this notion has been used in the court's case law, namely persons who've already been granted formally a right of residence in the host country. A subsequent withdrawal of that right, for instance because the person concerned has been convicted of a criminal offence, will constitute an interference with his or her right to respect for private and or family life within the meaning of Article 8. In such cases, the court will examine whether the interference is justified under the second paragraph of Article 8. In this connection, it will have regard to the various criteria which it has identified in its case law in order to determine whether a fair balance has been struck between the grounds underlying the authority's decision to withdraw the right of residence and the Article 8 rights of the individual concerned. So that's an interference. And if we look at footnote 24, and we find that at MS 2458, the cases cited are Bultseef, Una, Maslov, and then a couple of the subsequent ones. And in fact, if one goes back to Maslov, in the light of that, that's also in volume 6, it's at tab 67, and read it in the light of that subsequent decision of Jeunesse, a lot of things which didn't seem particularly significant seem more significant. So if we could just pick it up at paragraph 63 for a moment, which is at MS 2182. Furthermore, the court observes that not all settled migrants, no matter how long they've been residing in the country from which they are to be expelled, necessarily enjoy family life there within the meaning of Article 8. However, as Article 8 also protects the right to establish and develop relationships with other human beings in the outside world, and can sometimes embrace aspects of an individual's social identity, must be accepted that the totality of social ties between settled migrants and the community in which they're living constitutes part of the concept of private life. Regardless of the existence or otherwise of a family life, the expulsion of a settled migrant therefore constitutes an interference with his or her right to respect for private life. And we haven't particularly focused on the repeated use of the phrase settled migrant, but that's what Maslov, of course, was dealing with. It was dealing with somebody who'd been settled in Austria for many years since childhood. That wasn't the end of my dealing with Jeunesse. I just thought it'd be helpful to turn back and look at that.
But how is one to judge whether or not a person who isn't a settled migrant,
I'm so sorry.
how is one to judge whether a person who is not a settled migrant has a family life in the country?
They may well have a family life, but there's no interference with that family life by removing them or refusing to grant them a residence permit. And that's quite plain from Jeunesse. The question is...
If I'm not a settled migrant in England, as sometimes I think I'm not, but... well, if I'm not, and I happen to be married to an English woman who is a settled migrant, I mean, if I have been living here for 7 years, I mustn't take and personalize it because the example falls down on all sorts of counts, but if a person has lived here for, let us say, 15 years, she or he is not a settled migrant, but she has formed a relationship with someone who is a British citizen. What test does one apply to decide whether or not she has a family life for which she's entitled to claim respect?
She has a family life, plainly. The question is whether removing her, if she's here unlawfully, would be an interference with her right to respect for that family life. That's the question. And the question one...
That's quite an esoteric question. I mean, if the settled migrant has a family life, removing her from the circumstances in which she's enjoying that family life, how could that be said not to be an interference with her entitlement to respect for it?
Well, if she's a settled migrant, it is an interference.
Yes.
It's only if she's a non-settled migrant. If she's a non-settled migrant, the first question is, does she qualify for a settlement right under domestic immigration law? That's a matter for the state concerned, and we'll look at that in a moment. If she's in the country unlawfully, as these two appellants both were, and they don't qualify under the immigration rules, which they didn't, the question is, are their circumstances nonetheless sufficiently compelling that the state ought to allow them to remain and grant them residence rights irrespective?
No, you're asking two different questions. You accept, as I understand it, first of all, that somebody in the position of these claimants may well have a family or private life, in fact.
In fact, oh yes.
Secondly, do you agree that failing to admit them, refusing to admit them, and or deporting them if they're currently here, what can I say, disrupts that family life?
Well, I'd say that's the wrong question, my lord.
Well, I know you do. but it has an effect, does it, or doesn't it?
No, well, of course it has an effect as a matter of fact,
yes.
But as a matter of law, the question is does that demonstrate a lack of respect?
But you say, nevertheless, it's not an interference because there's no lack of respect, because no respect is called for
Yes.
for somebody who hasn't a right to arrive. Is that it?
That's precisely what I say, except if they have compelling circumstances. Yeah, and so I've started off, and what I've just been looking at is a case of the approach to settled migrants. I mean, I ought to say that I'm not saying here's what I say is the right analysis, I've just invented it and please accept it because it's correct. I say that's what we get from the Strasbourg case law. So if I've misread the Strasbourg case law, well, plainly, I'm just wrong. But I don't for the moment see that I have.
I mean, surely it's 105 is the one you're going on to, that no one was saying that these people didn't have a family life in Holland. They'd been there for more than a decade and had three children.
No,
the question was whether it was something which the state had a duty to respect, in the sense that they had a duty to enable them to exercise it.
Precisely. So 104 is looking at settled migrants and saying that those circumstances can be distinguished. 105 is saying these cases are not the same and you can't automatically adopt the same approach. Of course you have to strike a fair balance because the whole of the convention is the search for a fair balance. But the criteria aren't the same. They can't be transposed automatically. Rather, the question to be examined in the present case, i.e. a non-settled case, is whether, having regard to the circumstances as a whole, the Netherlands authority were under a duty pursuant to Article 8 to grant a residence permit, thereby enabling her to exercise family life on their territory. The instant case thus concerns not only family life but also immigration. For this reason, the case at hand is to be seen as one involving an allegation of failure on the part of the respondent state to comply with a positive obligation under Article 8. Now, that far you might think, well, it's a distinction without a difference, but where it becomes important is when we read down to 108. Another important, I'm not saying the passages, the paragraphs in between aren't important, they are, but they're very much the standard paragraphs. But another important consideration is whether family life was created at a time when the persons involved were aware that the immigration status of one of them was such that the persistence of that family life within the host state would from the outset be precarious. It's the court's well-established case law that where this is the case, it is likely only to be in exceptional circumstances that the removal of the non-national family member will constitute a violation of Article 8. And that's where you get.
A conflation of two concepts in this paragraph, because it starts off by saying whether family life was created. As I understand your anterior question, it's not an issue as to whether family life was created, but whether family life deserving of respect came into existence.
Well, that's the question at the end of the day, but where that family life was created in precarious circumstances It's only in an exceptional case that it will demand respect by the grant of a residence permit.
Do you get that out of the closing words of 108?
I do, yes.
What do they mean when they say it will only rarely, or in this case in exceptional circumstances, constitute a violation of Article 8?
Well, because there's a positive... They mean
By that it's only rarely that there will be any interference which requires justification?
Well-
Or do they mean that such interference will almost inevitably be justified?
no. What they mean is that it's only in exceptional circumstances that there will be a positive obligation. You've got to read it in the context of 105. 105 is saying the question to be examined is whether, having regard to the circumstances, a positive obligation arose.
Yeah.
And then at footnote 28, again 2458, the court refers back to Abdulaziz and the line of cases following that, which were all cases saying no interference. What we're looking at is a positive obligation. The line of authority referred to in footnote 28 is addressed in detail in our case at MS 3192. I won't take you to it now.
Paragraph numbers, just to help.
Oh, I'm so sorry. I
Sorry.
haven't written them down for myself. Oh, 59 to 64, I have. Thank you.
Thank you.
And I'm not saying that jeunesse is a departure. I don't think it is at all. I completely accept what my Lady Hale put to me. It's not a departure, but I think that the distinction hasn't always been clear, even in the Strasbourg case law. And,
I thought it was pretty clear in Rodriguez de Silva. I thought,
well,
more or less the same thing. Didn't it? I thought it did.
it certainly hasn't been clearly recognised in my respectful submission in the domestic authorities.
That is a much more...
Knotty question, yes. And it's one to which I'm going to move on. I mean, I did find that having read jeunesse and then looking back to read the older cases with hindsight, and this is, I'm sure, a failing on my part, just like paragraph 63 of Maslov, I thought, well, it's actually obvious. There are a string of cases where the court's looking at settled migrants and saying, has the state justified interfering with their life? They've given them a residence permit, they've been here for years, all right, a criminal offence has been committed, is it serious enough? And then there are the other strand of cases where the court says, in the particular circumstances of this case, do they give rise to a positive obligation? Are the circumstances sufficiently exceptional? Before we leave jeunesse, I wonder if I know Baroness Hale has said in the past that the dissenting judgments are often particularly illuminating in Strasbourg cases, maybe not in this context. I thought that the dissenting judgments...
They are in this court too.
I thought the dissenting judgments in jeunesse, which we haven't looked at before, were very interesting. The dissenters, sorry, pick it up at MS 2431 to 2433. And as I read it anyway, the dissent is really directed to the circumstances of the case and the conclusion of the case. And the dissenters took the view that that the Dutch authorities had looked at all the circumstances carefully, and the court had been guided perhaps more by what was humane than what was right, and it should have concluded that the decision fell within the margin of appreciation. In quite colourful language, at the end of 018, the dissenters said that the margin of appreciation, which was wide in such circumstances, has undergone a hot wash in this case. But
Did that include the Dutch judge?
I don't know whether Villager or Silvis are Dutch. Mahoney doesn't sound Dutch, but I suppose or Marnie.
Silvis is the Dutch judge.
probably not surprising. But I thought that the discussion of the general principles was quite illuminating, and we find that at 014 on MS 2432. The underlying question of principle is whether foreign nationals have a claim on the basis of Article 8 of the Convention to obtain from a contracting state permission to enter and or reside on the latter's territory in order to join or remain with their relatives who have legal residence there. In the Court's long-standing case law, this question is answered mainly in the negative. True, the Court does acknowledge that Article 8 is capable of being applicable under its family life head, but it's concluded most of the time that the immigration treatment accorded to these persons was not such as to violate this provision, regard being had to their situation and the general interest of the community. The overriding consideration highlighted in this case law is that they're foreign nationals, that's to say members of a category in respect of whom the states enjoy, under international law, as is stressed in all the relevant decisions, a virtually absolute right of control over entry into their territory and discretionary power in the matter of admission and residence. The Convention doesn't guarantee the right of a foreign national to enter or to reside in a particular country, and it doesn't prevent the contracting states from enacting into law and enforcing a strict, even very strict, immigration policy. And we saw that in some of the previous cases. You'll recall that towards the end of the last hearing, we looked at Biao, for example, where the Danish authorities have a cumulative residence test where they add up the number of years of residence in different countries. In concrete terms, the Court has taken the stance that a contracting state is not obliged under the Convention to accept foreign nationals and permit them to settle, except in cases where the family life could not be lived elsewhere than on its soil. In the great majority of cases, it's pointed out that such family life could flourish in another country.
Could I refer you to paragraph 121, please?
Yep.
It's at 2455.
Yes.
Where it says the central issue in this case, the central issue,
Yep.
is whether, bearing in mind the margin of appreciation, a fair balance has been struck between the competing interests at stake. Now, the competing interests at stake are identified as the personal interests of the applicant, her husband and their children, in maintaining their family life in the Netherlands, and on the other hand, the public order interests of the respondent government. And it's questionable whether general immigration policy can be regarded as sufficient justification. Well, now, if that's the central question at issue, is it not at least arguable that the fair balance test, which is conducted to determine whether there is a positive obligation in admission cases, is essentially the same as the fair balance justification applied in withdrawal cases?
Well, my respectful submission, no, it isn't, because the Court goes on at 122 to say the applicant's case must be regarded as exceptional. Accordingly, the Court concludes a fair balance hasn't been struck. So it's harking back to paragraph 108. It's the Court's well-established case law in precarious cases. It's only likely to be in exceptional circumstances that the removal will constitute a violation of Article 8. So you've got to read 105,
What were the exceptional circumstances beyond the personal family life that she had in the Netherlands?
Well, as I think we discussed in the previous context, exceptional circumstances are to be looked at cumulatively, and the Court went through a whole series of factors, but not least was the one that she had 3 children who had grown up in the Netherlands, that she was their prime carer, that she had originally been entitled to Dutch citizenship. So there were circumstances which the Court considered cumulatively were sufficient to make the case exceptional, albeit that the dissenters obviously thought that the Court had been a bit overgenerous.
It's quite, I mean, I find this pretty odd, this part of the reasoning to understand, but because at 117, you get the no insurmountable obstacles, and so they seem to accept that although there's some hardship, there were no insurmountable obstacles for the whole family up and going off to Suriname.
Yep.
But then at paragraph 121, the fact to which the, it's really 120, the fact to which the Dutch courts had failed to take into account was the practicality, feasibility and proportionality of any such removal, having regard to the best interests of the children. As I read it, it's the best interests of the children which is the key factor here. You've got
Yes.
3 children grown up in Holland who are Dutch citizens who have a right to stay there.
Yeah, that's how I read it as
And
well.
so although there are no insurmountable obstacles, when you
Yeah.
come on to consider exceptional factors, you look at it slightly more broadly.
Yes, and I think it's fair to say that when one looks through the Article 8 case law in the immigration context as a whole, the court does tend to be notably more generous in cases where children have resided for a substantial period, and particularly like here, they were born there, and the oldest one I think was 13 at the time, educated in the Netherlands. And yes, I mean, the best interests of the child are always a weighty factor.
So these appellants had happened to have children who lived here. Applying the reasoning in jeunesse, the probability is that the fair balance would be resolved in their favour.
I think it would probably depend on how old the children were and how, the Strasbourg court has also recognised that a very young child can more easily relocate than one that's, for example, in the middle of GCSE. So they are all very fact-specific cases. And
they need correcting on that.
sorry,
They need correcting on that.
what, on being fact-specific?
No, not on being fact-specific, but saying a very young child can more easily relocate than one.
Oh, I see.
But no doubt the argument hasn't been properly
Well,
presented to them.
Fortunately, I don't have to argue it in this case because we have no children. It's a great relief to me.
Enough
There
to
are
argue
enough
about.
difficult issues without looking at...
If you're right that the correct reading of all this is that in the absence of the sort of exceptional circumstances which persuaded the Strasbourg court in jeunesse, there is no family life which is entitled to respect and therefore no interference. When you get to the presence or the suggested presence of exceptional circumstances, do you then have one question or do you have two? Do you have simply, is there something exceptional which in effect requires that this person must be admitted? Or do you have stage one, there is something exceptional which demonstrates that there is a family life to which respect must be accorded, and then go on to stage two, is there enough respect being accorded to it?
No, just one question.
Just the one.
Just the one question.
And you say that differs from the ordinary proportionality question.
Yes. Yes.
And the single question is the second of my Lord's questions, namely that there must be, about the circumstances of the family life, sufficient to impose a positive obligation to admit the person.
Yes. And sometimes the court talks about it as admitting them, sometimes it talks about it as refraining from removing them. It doesn't regard the two as one being a positive obligation, one being a negative. They're just two sides of the same coin. The question is the same one. Are the circumstances sufficiently compelling to require the state to allow them to remain?
Can I just ask you, the term unjustifiably harsh consequences, which is used in your Secretary of State's guidance, one doesn't find replicated in jeunesse. Does it come from any other authority, or is it something which is advised by the Secretary of State?
Well, sometimes a lot of emphasis on language, as I've said in previous in the
I'm not
previous
saying
areas.
there's anything wrong with it. I'm just wondering whether it comes from anywhere or whether it's simply
No.
the Secretary of State's interpretation of.
It's not a standard phrase, but one sees repeated in the Strasbourg authorities, for example, in 121, whether there is justification.
Yes.
Yeah. So, and the Secretary of State analysed her exceptional circumstances, or the guidance she gave was, of course, by reference to Quila and the domestic cases. So it talks about, would the consequences be unjustifiably harsh so as to be disproportionate? But effectively, we're looking at the same thing. Is this a compelling case? We're notwithstanding the fact that the person's here unlawfully, the status is precarious, they don't qualify under the rules, they don't meet the various criteria for financial requirements, for example, for maintenance, for accommodation, they should be allowed to remain anyway.
But it would be irrelevant whether they met the eligibility requirements, wouldn't it? Because under the rules, you only qualify under FM as a partner if you're out of the country.
No.
Is
No,
that,
no,
have I got
no.
that wrong?
No, I'm afraid so, yes.
Oh, good. I'm glad I've got it
Yes,
wrong.
no. You can switch. The only people, so you could be here as a student, for example, or a business person, and apply to switch to the family life category. I'd marked up for myself the relevant bit you need to look at. The people who can't switch are people who are here as visitors or for less than 6 months, or people who are here unlawfully. Everybody else just makes their application and puts forward pay slips,
No, but what I'm getting at is, it's always been accepted that these two, it's the same point. It's always been accepted that these two had to apply either for X1 to apply or outside the rules.
Yeah.
Notwithstanding the fact that they had been here as overstaying visitors, in one case for very many years, in the other case for quite a few years. And what's the bit in the rules that says that they weren't allowed to be considered in the ordinary way as spouses or partners? There must be something in the rules that excluded them. It's not in the decision letters because no doubt it was never suggested they did fall within.
No, that's right. It was put forward specifically on the basis that they didn't, certainly in one of the cases. It's Authorities Volume 1, Tab 5, MS page number 70. It starts, the section E, LTRP, eligibility for limited leave to remain as a partner, starts at the bottom of MS page number 69. Then we have the relationship requirements. Then there's a heading at the bottom of MS page number 70, immigration status requirements. The applicant must not be in the UK, 1 as a visitor, B with valid leave granted for 6 months or less. ELTRP 2.2, the applicant must not be in the UK on temporary admission or temporary release unless, paragraph EX1 applies, or in breach of immigration laws, disregarding any period of less than 28 days of overstaying, unless paragraph EX1 applies. So we get to paragraph EX1 because they're here in breach of immigration laws. If they've come in lawfully and formed a relationship or remained lawfully, then they just apply under the usual maintenance and income requirements. So I was going to deal with this when we came to the scheme because it seems to be important. We're starting off very often as if any foreign national needs to show there are insurmountable obstacles. And my Lord Kama said this morning, well, if I married somebody from a third country, how do I go about bringing them in? Do I have to show insurmountable obstacles? Well, no, not if you abide by the immigration rules and make an application under the rules. We're looking here at a small proportion of people who are not here lawfully in the first place, and that's why we're in this territory.
Are they a small proportion of people?
Well, you had the figures this morning. If you compare them to the figures that you had for applications for leave to enter, I think they are. I haven't done the comparison, but I think they are a smaller proportion. Mr. Peckover, tell me if I'm wrong. I'm also told that the EX1 group is thought to be particularly significant at the moment because a lot of people who wouldn't have had any avenue to apply under the rules, under the old system, can now come forward and apply under EX1 because previously there was no provision in the rules for people to apply for leave to remain under Article 8 grounds if they were here unlawfully. They just had to ask for an exercise of discretion if they're going to be removed. The rules didn't provide for a grant of leave. And one of the reasons for EX1 was to encourage people to come forward and regularise their status.
Ms. Giovanetti, you remember that this morning I asked Mr. Saini whether the scheme, insurmountable obstacles plus discretion, only applied to people who had entered into a relationship on a precarious basis. And he said, no, actually, it goes further. You could have people who come in pursuant to eligibility requirements which they meet, and then later, after a year or two, they no longer meet them. And in those circumstances, that sort of union is subjected to this scheme. Was he right?
Yes, I think he was. Yes. But fortunately,
You said it was for those who are here illegally, so it's those who start their relationship here precariously and those whose relationship, because of, say, a failure to get the English language test or an alteration of financial circumstances, become illegal.
and it may be that there are different arguments in those cases, but that's not what we're concerned about at the moment.
The two cases here are far removed from that.
Yes, they are. Yes. And I don't have all the guidance that apply. I mean, people wouldn't be removed, as I understand it, because they failed to meet the maintenance requirement in the course of, somebody becomes unemployed after a couple of months. But they have to make a further application halfway through. So they are not settled until they've reached the end of the settlement process. So there are very different arguments to be had in those circumstances. But he's quite right in saying that those cases will fall under these provisions of the rules, but the analysis would be markedly different, and I am not suggesting that it's transposed automatically, but we're concerned here with plain precarious cases.
Well, does the guidance help caseworkers realise that very different considerations apply?
I didn't say I said very different considerations may apply. I mean, I'm focusing here on the circumstances with which we're concerned in these appeals, which I find challenging enough. I haven't gone beyond it to look at the process that's gone through when people reapply for their extension at half time.
We are looking at the adequacy of the guidance. I know in this particular context that it may not be irrelevant to consider whether, bearing in mind this other constituency that you accept falls within the scheme, and you're very reasonably saying different considerations may apply.
Yes.
But there's nothing about that in the guidance.
Well, the guidance does... Well, oh dear, I'm going to get... sorry, I didn't mean to say I was going to get sidetracked in sort of an impolite way. The guidance does make it plain that you look at, for example, how long they've been here lawfully. I wasn't going to go to the guidance just yet, but I shall.
In your own time, Ms. Giovanetti, please.
Sorry.
Please.
In case I forget, my lord, can I just flag it up at the moment, and then we'll come back to it. But the current guidance is probably the most germane for those purposes, which you've got in volume 1. Okay.
That's 3276, May 2013. Oh no, the current guidance.
I'm looking at the current guidance because we're looking now at how the guidance would work in other contexts. Yeah. So probably you're more interested in the current guidance. If you turn to MS page number 371, so, I mean, I'm looking at this for the moment just to show that there is a difference in the approach depending on the immigration status will be relevant. If you look at the third bullet point down on that page, factors that weigh in the balance include the immigration status of the applicant and their family members. Decision makers should take into account the circumstances around the applicant's entry to the UK, the proportion of the time they've been in the UK legally as opposed to illegally. Did they form their relationship with their partner at a time when they were in the UK unlawfully, etc. So all those factors will be taken into account. But I haven't looked in any detail at the case law about this because it's just not these cases.
Understood.
Is that helpful? I hope
Thank
it is.
As a matter of practice, just very quickly, what do you normally get if you come in under the rules, under the income qualifications or whatever? Do you get a year?
30 months, I think.
30 months.
30 months. Sorry, could I...
And basically it's after 5 years that you're settled, yes?
Yes.
So you've got one renewal at least?
Yes. That's my understanding. Can I check? To be precise, you get a 33-month visa. You have to apply for further leave after 30 months, and you get indefinite leave after 5 years.
So the situation which Lord Wilson and Mr. Saini were discussing this morning can arise, as you say, and it will arise if it does at the 30-month, at the halfway stage of the 5-year period.
Yes, but I think it's fair to say the balancing exercise would be very different at that stage.
Got that point.
Yeah.
What's the process? We might as well track this one down to the end. What's the process if you come in under the tenure route? How often do you have to renew yourself?
Could I briefly turn to Mr. Peckover again? Thank you. You don't come in under the 10-year route, you don't enter under the 10-year route unless there are exceptional circumstances.
Yep.
And Mr. Peckover reminds me that that's the very aspect, or one of the aspects of the policy that we've undertaken to review in the light of the comments, principally by my Lord Wilson, but by the panel generally in the MMSJ cases. That, and of course you'll recall the circumstances relating to children outside the UK, which is something else where the policy is being reviewed at the moment.
I appreciate the tenure route is when you come in outside the rules,
Yeah.
which I think we're calling exceptional circumstances. I appreciate that. But I just wondered, what's your pathway to getting settlement if you come in under that route?
You have to apply again at various intervals,
Yes,
do you mean?
right.
Every 2.5 years. Which I think, unless my maths has completely deserted me, is every 30 months. Maybe it has.
Thank you.
The cases leading up to Jeunesse are all discussed in Nargray in the passages I've already directed you to. I wasn't going to say any more about them unless you would like me to, or unless you thought that would be of assistance. Maybe more sensible if I move on, given it's 20 to 4, to the second tranche of my submissions on the domestic case law. And I don't want to be unfair to the appellant, but I think the appellants tentatively appear to accept that if one looks at it purely on the basis of the Strasbourg case law, our analysis is right. But they say that the domestic courts have taken a conscious decision to depart from the Strasbourg case law and effectively adopt a more generous approach. And for example, in their case, which is in the core volume, picking it up at MS page number 3158, at paragraph 216, having had due regard to the jurisprudence of the European Court of Human Rights and several authorities, this court has lawfully and correctly declined to follow the very letter of the Strasbourg jurisprudence, having given valid reasons for departing from it where relevant, and notwithstanding repeated attempts by the Secretary of State to lower the protection given to those fundamental rights to the minimum threshold that Strasbourg has set. And then the arguments developed, and at 221, picking it up in the fourth line down, halfway through the line, the appellants submit that the domestic court should continue to decline the Secretary of State's invitation to mimic the tests and thresholds of Strasbourg jurisprudence. My Lords, we've addressed this in our case, which is in the same volume, at pages 3187 to 3188. Sorry, my numbers don't run sequentially, which is a bit disorientating. It's paragraphs 46 through to 48. I'd like to expand a little upon that, if I may, and I'd like to start off by looking in a little more detail at the Ambrose and Harris case.
Sorry, which paragraph are you starting off with?
Sorry, my lord. Our case, paragraphs 46 to 48.
Thank you.
And at 47, we cite a number of authorities, including Ambrose and Harris. And I'd like
Sorry,
to...
before we get to that, are you about to say that some of the UK authorities depart from the journalist approach?
No, I'm going to say there's
You're
been no
refuting that argument, as I understand it.
Sorry, my lord.
You're refuting the argument.
I am
that
refuting that argument.
That there is a more generous approach in the UK.
Yes.
Okay.
My
As long
argument...
as I know where we're going.
No, yes, sorry. My submission is that the domestic courts have never taken a deliberate decision to depart from the Strasbourg case law and be more generous. What we do get sometimes is a shorthand reference to the tests that emerged from Boulty, Booner and Maslov, and no clear statement that that's limited to settled migrant cases.
I see, okay.
But it's not a conscious or deliberate decision to say Strasbourg is less generous and we will be more generous.
So you don't need to ask us to depart from any previous authority.
Well, I think there may be aspects of the reasoning in Quila which are problematic, but I certainly don't need to ask you to depart from Huang or EB Kosovo or anything that's specifically on point. And what I'm going to ask the court to do, I think, is loyally follow the approach in Ambrose and Harris, which is to look at the Strasbourg case law and interpret the content of Article 8 consistently with that, as it's been clarified. So Ambrose and Harris is in the authorities at volume 3, tab 28.
Ambrose and Harris was perhaps dealing with a different question. The problem in Ambrose and Harris, I think, was essentially that the court was faced with a question under the Human Rights Act to which the Strasbourg jurisprudence didn't provide a clear answer.
Yes.
And the question in that situation was, could one, as it were, extrapolate and assess what the answer ought to be as a domestic court?
Yes.
Now, in our situation, it's not quite the same as that, is it?
No, I absolutely agree. But as I understand it, the appellant's submission is probably most clearly put in reliance on EB Kosovo.
Yeah.
And I say that their analysis of EB Kosovo is just wrong because it's inconsistent with Ambrose and Harris. And maybe that would be the easy... Could we go back to Nargray? Because this argument was dealt with there. And I think that's volume 5, tab 52, where exactly the same argument was being run.
'52.
52, yeah. And can we pick it up at MS page number 1641? Paragraph 44. And I think it's fair to say that EB Kosovo is the high point of the appellant's case. And it echoes the argument that was being advanced by Mr. Malik in Nargray. Mr. Malik submitted, although it might be possible to derive all this, and that's the exceptional circumstances approach, from the Strasbourg cases, this is not an approach or a conclusion which is open to a domestic court at first instance level because of what's been said by Lord Bingham in EB Kosovo and by the Court of Appeal in BW Uganda. At paragraph 12 of his speech in EB Kosovo, with which the other members of the appellate committee agreed, Lord Bingham said, "Thus, the appellate immigration authority must make its own judgment, and that judgment will be strongly influenced by the particular facts and circumstances of the particular case. The authority will, of course, take note of factors which have or have not weighed with the Strasbourg court." I pause there to say that in my submission, that is the statement of principle. Lord Bingham continues, it will, for example, recognise that it will rarely be proportionate to uphold an order for removal of a spouse if there is a close and genuine bond with the other spouse, and that spouse cannot reasonably be expected to follow the removed spouse to the country of removal, or if the effect of the order is to sever a genuine and subsisting relationship between parent and child. And at 45, Mr. Malik contrasts the language of cannot reasonably be expected to follow the removed spouse to the country of removal with a formulation based on insurmountable obstacles. He submits that Lord Bingham rejected an approach focused on a test of insurmountable obstacles to relocation in favour of a looser test, more generous to applicants for leave to remain in family life cases. And then the citation from VW Uganda. And at 46, the judge says, contrary to the submission of Mr. Malik, I do not think it's right to try to read Lord Bingham's statement in EB Kosovo as a canonical formulation of the test to be applied. That's the reasonable to expect them to follow test. The basic point he made was that the domestic courts should seek to follow the general approach to the application of Article 8 in immigration cases to be identified from the Strasbourg case law. And then picking it up I'd ask you to read all of that paragraph because it's important. It says there's no detailed consideration of the Strasbourg case law there. What you'd expect if he was saying that the courts should part company. And then picking it up, 5 lines from the bottom, the line beginning, indeed, I think that Lord Bingham was seeking not to be unduly prescriptive in paragraph 12 of his speech and indicated that the domestic court should refer to the Strasbourg case law for guidance, precisely because of a consciousness of the difficulty of producing clear, crisp and definitive encapsulations of the Strasbourg case law on the issue, which I would echo wholeheartedly. I mean, it is very difficult.
Well, what a surprise.
And then I rely, as I said, I think earlier, on all of the reasoning through to the end of paragraph 49. So I say EB Kosovo cannot be read as a decision on the part of this court that the domestic court should part company with Strasbourg and adopt a more generous test. And it would be astonishing, in my respectful submission, if that is what Lord Bingham was doing.
Well, what did he mean by saying it will rarely be proportionate to uphold an order for removal of a spouse if there's a close and genuine bond with the other spouse?
Well, because he was broadly summarising the effect of some of the Strasbourg case law, and that's probably an accurate encapsulation of Bulti, Funa and Maslov, but as we've seen, the Grand Chamber has now made it clear beyond doubt that those cases are to be distinguished from the precariousness cases. And so, in my respectful submission, if Lord Bingham intended to say, whatever the Strasbourg court may say in the future, we will apply this test, he would have said so.
But he ought to have said, if the other spouse, of the spouse to be separated is a settled migrant.
But I endorse entirely what Mr. Justice Sales said in that case. All he was doing was giving a broad summary of what the thrust of some of the Strasbourg case law is.
Well, that's one way of characterising it, but another way of looking at it is a pretty plain, unequivocal statement. It's a fairly pointed statement, giving a particular example.
I hear what my Lord says. All I can say in reply is that my submission is that if Lord Bingham had been intending to say that the domestic courts should deliberately apply a more generous test than the Strasbourg court, that's what he would have said. And that's why I was going to take you to Ambrose and Harris, because part of my rationale for saying that is that Lord Bingham was actually very careful to say that the domestic courts should not enlarge the rights in Strasbourg beyond the reach of the Strasbourg court itself. And I absolutely accept what my Lord Rees said. The submission in Ambrose and Harris wasn't nearly as ambitious as a submission that we should deliberately choose to depart from Strasbourg. What was being said in Ambrose and Harris was, they haven't quite got there yet, let's anticipate it. But it's quite plain.
But it wasn't with respect, let's anticipate it. Let's do our duty under
I'm so
Section 6.
sorry, my lord. You see, that was a broad generalisation, generalised submission on my part, which maybe I should have formulated more carefully. I had marked up a section from my lord's judgment, my Lord Kerr's judgment. I can just find it on my yellow highlighter. Yes. I'm sure it'll be very familiar. It's at paragraph 129, and what my lord said was, MS 1012, I'm sure my lord will know it very well. It's therefore the duty of this and every court not only to ascertain where the jurisprudence of the Strasbourg court clearly shows that it currently stands, but to resolve the question of whether a claim to a convention right is viable or not, even where the jurisprudence of the Strasbourg court does not disclose a clear current view. And that's what I understood Ambrose and Harris really to be about. But what I'm saying is that in this context, the jurisprudence of the Strasbourg court does disclose a clear current view. It's the view of the Grand Chamber last year, and it's, in my respectful submission, sufficiently clear to be well understood.
Mr. Giovanetti, it might be said that Lord Bingham's formulation in EB Kosovo cannot be determinative, because what a spouse can reasonably be expected to do will depend on the circumstances. And if the circumstances are that the spouse has knowingly engaged or entered into a relationship in circumstances of immigration precariousness, it may be more reasonable to expect that spouse to keep that relationship going to emigrate than it would be if it was a settled spouse.
Yes, and
it seems to me the argument to the contrary is seeking to put an awful lot of weight on the expression reasonableness, but it's reasonableness in the circumstances.
I would entirely accept that, and I did think about sort of expressly making that submission, but I think that's absolutely right. What's reasonable is not just to be seen in terms of would somebody like to, or have they chosen to, or are there reasons why they'd want to stay in the UK, like they have a job. But what's reasonable has to be context specific, and in this context we see that it requires something exceptional. Yes. Even if you put it in, yeah.
Because the argument that you're facing is that there's a fairness test or there's a reasonableness test, and that cannot allow for exceptional circumstances. I ask the question, why not?
No, precisely.
Because it's fairness or reasonableness in the circumstances.
Absolutely, yes, absolutely. I would accept all of that, which is why I started off by saying I don't depart from the fair balance. But what is it a fair balance requires in this context? It's something exceptional. So I may not need to go to this at all, but could I just draw your attention to the judgment of Lord Hope, picking it up at MS page number 974. At paragraph 16, he cites the well-known passage from Aukenbury, and at 17 he moves on to Ulla, which of course is Lord Bingham's speech. Could I ask you to read 17? I'm so sorry, I'm getting rather hoarse. Only have 4 minutes to go. So really just A to B on page MS 975. Then at 19, the reference to Lord Bingham's further observations in Brown and Stott. And then if I pick it up by letter H, the consistency between this passage, that's Brown and Stott, and what he said in Ulla's case, shows that Lord Bingham saw this as fundamental to a proper understanding of the extent of the jurisdiction given to the domestic courts by Parliament. And I pick it up again on the next page, 976, second line. Lord Bingham's point, with which I respectfully agree, was that Parliament never intended to give the courts of this country the power to give a more generous scope to those rights than that which was to be found in the jurisprudence of the Strasbourg court. To do so would have the effect of changing them from convention rights based on the treaty obligation into freestanding rights of the court's own creation. That's why the court's task in this case, as I see it, is to identify as best it can where the jurisprudence of the Strasbourg court clearly shows it stands on this issue. It's not for this court to expand the scope of the convention right further than the jurisprudence of the Strasbourg court justifies. And
the last sentence of 19 is odd, isn't it, Ms. Giovanetti? reference to convention rights based on treaty obligation. In our 1998 Act, we went far further than that. They are now domestic rights, aren't they?
Well, I mean, this is a 2011 decision,
Well, quite.
and this is a judgment that was agreed with in full by the majority of the court. So we have Lord Brown at paragraph 73 and 86, Lord Dyson at 88.
They are convention rights, because that's what they're described as in the Act.
Yes, yeah, that's where they stem from. They stem from the
Well,
convention.
historically, they're based on treaty obligations,
Yes.
but they are now part of our domestic law.
Yes,
I think Lord Hoffman made that unequivocally clear, as did my lady in Re G.
yes, I accept that they're in domestic law, but as Lord Bingham said, the content of those rights is ruled upon by Strasbourg. That's what the content, I mean, it's Strasbourg who tells us what the content of Article 8 is.
You probably should avoid the debate as to what ULA means, because essentially, at the end of the day, your point is you don't have to worry about any lacuna in the Strasbourg jurisprudence. Strasbourg jurisprudence is clear, and on one view, and it's one that I happen to hold, what Lord Bingham was saying essentially in ULA is where it is clear, we should follow it.
Yes, and that's enough for my purposes, I hope. And it's now, I think, 30 seconds to 4 o'clock. Could I stop there for today?
Yes, and recover your voice overnight.
Thank you, I'll do my best. And I will try and pick up speed a little bit tomorrow. I think those were the most conceptually difficult parts of my submissions. I hope so anyway.
Thank you very much indeed.
Thank you, my lady. Thank you, my lords.
2 o'clock.
2 o'clock. Yes. Thank you.
So am I, unfortunately.